It is great to see your bright faces here and to be together in this great day. My name is Hale. I am with Solventum. I'm a data scientist, and I've been building machine learning model for a while at 3M and then later on in Solventum. And I'm the chair of the morning session. It's my pleasure to introduce our speakers to you. And please remember that we have a dedicated Q&A at the end of the talk. So if you could please hold your questions at that time and ask them at that time, we really appreciate it. So it sounds like the advances of AI are outpacing regulation by leaps and bounds. So that's why our next talk is really interesting. Melissa Krasnow is recognized nationally for her work in privacy and data security and cybersecurity at its intersection with technology. She has an impressive background in handling data breach incidents and is a highly regarded attorney whose broad practice exhibits a strength across a number of technology-related issues. She is with VLP Law. Please help me welcome Melissa to the podium. Look forward to your talk.
Thank you so much. It is great to be here. I spoke at the last WiADS conference when it was online in 2020, and it was about this time. It was actually, I think it might have been Halloween or just before. Interestingly, if you think about it, it was before another presidential election. So there you go. I'm delighted to follow Kathy O'Neill, and there's absolutely no pressure because she said not only would I talk about AI laws, I'd also talk about privacy laws, but good news, I am prepared. I will not talk about EU AI laws. You do have another speaker who's covering those. There's plenty, and I'll try to get through my presentation. So I emailed people I know, guess what, there's this great conference, it's oversold, you can register virtually. And someone wrote me back, that's great, this sounds interesting. Hey, what's so special about this Colorado law? Aha, that's my hook, so that's my intro. What's so special? Here's what I emailed this person back. What's really interesting is it is law. It's before California's law came, and California has some laws that have been signed by their governor. The Colorado governor, Jared Polis, signed it. It is law. But when he signed it, he had some reservations, but yet he signed it. Guess what? After he signed it, very shortly after, and this wasn't reported a lot in the media, he said, you know what, I'm not so sure. We're going to convene a task force with the Colorado governor, the Colorado attorney general, and the Colorado Senate majority leader, and we're going to revise the law. We want to minimize unintended consequences from implementation. Interestingly, this law also has rules. It doesn't have them yet. Some laws, there's the law, and then it's really implemented by the regulation or the rules. This is an example of that. So there's still rules to come. That's going to be out of the Colorado Attorney General as well. So I'm going to say this a lot through my presentation. Stay tuned. Things are in flux. Even if you have a law, it can be amended, right? So I want to level set approach, and this is where the privacy laws come in. Perhaps you've heard of consumer privacy laws. Has anyone heard of California Consumer Privacy Act, California Privacy Rights Act? In Minnesota, we do have the Minnesota Consumer Data Protection Act, not in effect. It will be in effect next July 2025. Have you all heard of these? Maybe you've asked about your data rights on a website. Okay, so Colorado has one of these laws. So also part of my response, guess what? Colorado has one of these laws. Some of these privacy laws, I think, are addressing artificial intelligence as well, and maybe that was what Kathy was trying to get at. Here's what's interesting. The Colorado Attorney General enforces both their consumer privacy law and this artificial intelligence law, so their enforcement authority is broadened. They're already important, they're going to become that much more important. So, another level set, I look at these laws like, how populous is the state? So any guesses, if you had to rank top state for population, I think everyone would guess, is California. That's correct. Any guesses for Colorado? 22nd. Oh, sorry, 21st. Near 6 million people. For some reason, I'd think it would be more populous. Minnesota is 22nd, a little fewer than 6 million. Interesting, like I would have thought Colorado's bigger, but who knows? California close to 39 million, by far the most populous state. So think of state populations and then states having these laws. Okay, so let me get my clicker. Let's talk about Colorado. The law is the law. Right now it's not effective. There is rulemaking, but that's not finalized. Colorado Attorney General has exclusive enforcement authority. What does that mean? If you're a company, as a practical matter, you don't want to be sued. You could be sued by the Attorney General, but you don't want to be sued by a plaintiff's lawyer. Some laws give plaintiffs' lawyers the ability to sue. They explicitly, this law does not, although there was some interesting drafting, but I think let's just presume it's Colorado attorney. It doesn't overwhelmingly say. It doesn't stop a plaintiff's attorney, it just makes it a very uphill battle. So I think plaintiff's attorneys will pick their battles, right? If it gives them the authority to sue, that's a bonus, they will proceed, they'll use that law. And there is a role, I think, for plaintiff's attorneys. I'm not thinking about them negatively. I do think they help people, they enforce rights and laws and help with that. Okay, so a couple things. Like the consumer privacy laws, everything about these laws is about definitions. And sort of like those Russian dolls, you open one and there's like another Russian doll inside, and within that there's another. That's what the definitions are like. There are definitions within definitions. So it's a difficult read. So do people actually read the law? No one needs to answer that question. But they're filled, and the definitions are really important. In fact, I mentioned about Colorado saying, hey, we're gonna look at this again, we're gonna probably revisit it and amend it. Part of the issue is the definitions. So I will go through a few. I was debating, like, how many slides am I gonna have? Am I gonna overwhelm everyone with definitions? But yet the law does that. So first part, who does this apply to? It applies to deployers and developers, and they are defined. So deployers is what I think you would think, although it is a defined term. Developer, develop or intentionally and substantially modify an artificial intelligence system. Artificial intelligence system, I'll get to it, is a defined term. Of a high-risk artificial, another defined term, that's a definition within a definition, doing business in Colorado. Okay, so there's intentional and substantial modification, that's defined. Deliberate change made to artificial intelligence system that results in any new reasonably foreseeable risk of algorithmic discrimination. Huge definition, and I was debating, should I put this on a slide, and I didn't. So what does Colorado say algorithmic discrimination is? Condition where use of artificial intelligence results in unlawful differential treatment or impact that disfavors an individual or group on the basis of their actual or perceived age, color, disability, ethnicity, genetic information, limited proficiency in English language, national origin, race, religion, reproductive health, sex, or veteran status, or other classification protected under Colorado or federal law. If you want these definitions or anything, you've got my contact information. My firm, you can find me you can email me, and I've got stuff. So by all means, and I will respond. Okay. High-risk artificial intelligence system. I've got the definition up there on the slide. So here's the point. High-risk artificial intelligence systems used a lot, but in some places in this law, it's just artificial intelligence system. So be mindful, and it makes these laws just kind of tricky. But I want to point out some definitions within the definition of high-risk artificial intelligence system. Okay, it is So in the parens is actually the definition of artificial intelligence system. Okay. All right. What I want to point out is, look at the end. Consequential decision, substantial factor in making a consequential decision. I don't have those on the slides. Those are additional definitions. Decision consequential, that material, legal, or similarly significant effect on provision or denial to any Colorado resident. So this applies to Colorado residents in addition to developers and deployers that do business in Colorado. In terms, and it's things that Kathy was talking about, education opportunity, employment opportunity, financial or housing service, essential government services, healthcare service. Actually, I think it's everything. Housing, insurance, or legal service. What's a substantial factor that assists in making a consequential decision? And it's capable of affecting or impacting. I'm trying to be general. So another thing, and the consumer privacy laws are like this, not with like algorithmic discrimination, but they have definitions within definitions. Another thing I want to point out, and it's actually very similar to the consumer privacy laws, oh my God, is everyone covered by this law? They actually aren't. What's also just as important are exceptions to these laws. So for example, in some areas, if you're a small business, and they don't use the term small business, but they kind of define it, you may not have these obligations. Other types of businesses, regulated businesses, other types of activities, they are not within the law. So you have to look at the exceptions as well. It's a lot. So there are exceptions. They're voluminous. I did not do slides for them. So, but if you want to email me, happy to send you more information. Okay, so if you're a deployer or if you're a developer, what do you need to do? And there's a host of things, and it's kind of broken down between whether you're a deployer or a developer. So deployer, implement a risk management policy and program to govern high risk, not just mere artificial intelligence system, to govern high risk artificial intelligence system deployment. You have to notify and disclose to Colorado residents about deploying high-risk artificial intelligence system, but there's more definitions, or be a substantial factor, definition, to make a consequential decision about the Colorado resident, another defined term, consequential decision. You have to do a deployer website statement regarding high-risk artificial intelligence system. There's a standard of care, reasonable care to protect Colorado residents from any known or reasonably foreseeable risk of algorithmic discrimination, another definition. What happens if there's algorithmic discrimination? As a deployer, you have to notify the Colorado Attorney General. So often, and this happens under other privacy and data security laws, how do regulators find out? They can find out through social media. They can find out if someone complains, like a state resident, and people do. People, I say, are very random. You would think they'd complain to a company if they're upset. No, they might just go directly to the Attorney General, and the Attorney General will get wind of something and maybe investigate, maybe not. Interestingly, like in a data breach, how many of you have gotten data breach notices? Okay, everyone, unfortunately. So in most states now, as these laws have evolved, you don't just notify the individual, you also, and it depends on the state and how many people are impacted, have to notify the Attorney General. Guess what? This is how they find out about breaches. What happens when they find out about a breach? Not only may they choose to investigate the breach, ask the company questions, I call it a window into a company's activities. They say, hey, where's your data security program or your written information security program? What are you doing? So it might open a window. In other words, you're notifying a regulator that something's gone wrong. So what do you think is going to happen should someone notify the Colorado, hey, we've done algorithmic, what do you think will happen? Is there a risk that they may investigate? I think so. Okay. Additional deployer obligations. This is really interesting. If the deployer has a third party, like a vendor or service partner, depending on who it is, they have to complete a high-risk artificial intelligence system impact assessment. So really interesting, there is something very comparable under consumer privacy laws. And in other words, the company sort of has to assess for themselves, how is this impacting? And the question is, are they given guidance? In Colorado, really interestingly, their rules for the Consumer Privacy Act almost provide a roadmap for this. Ooh, 5 minutes, I'll scoot. This is important. Let's see. I'm going to skip ahead. Developer obligations. There's got to be a general statement describing reasonable foreseeable uses and known harmful or inappropriate uses of the high-risk artificial intelligence system and documentation. They've got to do a developer website statement about high-risk artificial intelligence. They've got to also make a disclosure to the Colorado AG of algorithmic discrimination. They also have to use reasonable care. Okay, sorry about that. This is really important. So why is Colorado important? Maybe it is the way ahead with state laws. So stay tuned. I'm going to go to other states. Believe it or not, there's another state with one of these laws. Utah, 30th most populous state. Again, I would have thought it was more. They have an artificial intelligence act. It deals with generative AI. It is more restricted or limited. What you need to know about California, you may have read about this in the news, their Governor Gavin Newsom, did not sign a very important bill, the SB 1047. He said the bill applies stringent standards to even the most basic functions so long as a large system deploys it. I do not believe this is the best approach on protecting the public from real threats posed by the technology. Guess what? He convened his own task force. The godmother of AI, Dr. Fei-Fei Li, as well as Tino Cuellar, member of National Academy of Sciences, and Jennifer Torches, Dean of the College of Computing Data Science at UC Berkeley, will help lead California's effort regarding guardrails and responsible use of generative AI. So California is considering it yet, and California did pass other laws. They're more limited in a variety of areas. Here's what I want to wind up with. California, 39 million people. All right, what's the second most populous state? Any guesses? Yay, you're right. And close to 31 million people. Guess what? 1 week ago, Texas Representative Giovanni Capriglione unveiled draft legislation known as the Texas Responsible AI Governance Act. Think about it. California and Texas, the two most populous states. Colorado has a law, Utah has a law, not as populous, but the Colorado Attorney General has lots of power. All 4 states have consumer privacy laws in effect. Prediction, there will be more state legislative activity ahead, so stay tuned. Did I make it? Okay. Thanks.
We have a question online what are your thoughts on the fragmented landscape of AI and privacy laws in the US and their ability to be enforced? How does the complexity change when looking globally?
When you say the word globally, do you mean worldwide, or are you saying, more widespread? Is that the gist of the use of globally?
Yeah, I think the first part of it was talking about the US, but then if that's different globally.
I will punt the second global part to our EU speaker and give her a shout out right now. In terms of US, it's going to become more complex. So if you step back a year ago, there weren't as many laws, or if any. And so once you have laws, the question, people scramble, how do we comply, how do we comply? And then the issue where the rubber meets the road, I think, is sort of twofold. Is this enforced? So State Attorney General's office, so Colorado is one example. This is not the only thing they're enforcing. Will they enforce an AI law? I think they will, but it sounds like they pick their battles. So I think I'll take you back to California, California Consumer Privacy Act. Where's the enforcement? Where's the enforcement? Did it happen on day one? It did not. There was a time. There was time that elapsed. So that's what everyone's looking to see. But the Attorney General picks their battle. They have to choose who to enforce against. And so anyone's guess is as good as mine. More complexity, absolutely. And as I mentioned, Minnesota has a consumer privacy. It deals arguably with algorithms and AI as well. It's not as explicit, but a lot of these laws cover. Okay, next question. Sorry.
Hi. You mentioned that quite often these sorts of laws don't apply to small businesses. What happens when a small business contracts with an outside party, maybe a company outside of Colorado, for example, that is doing sort of nefarious things with their software or their services that they're offering? How does that work in the mix?
That is a great question. So I didn't say small business. So Colorado has certain exemptions for what would be considered. First of all, number one, whether a small business is, it depends on the law, right? So Colorado's does, you'd look at the other law. So that's a great question. Like in this whole technology ecosystem, one company doesn't do it all. Typically there are vendors and contractors, and often they are smaller. So let's take your example. Right, the small business is carved out, let's just say, from Colorado, but they're with Goliath. I'll call them Goliath is contracting with them to help them. Do you think Goliath might try to impose some of their obligations on the vendor, and if there's an issue, if you will, throw the vendor under the bus? That happens. I think you're also seeing that in the case of data security laws. A great and local example, the CrowdStrike issue, and Delta is suing them now in court. CrowdStrike was the vendor. Who knows who's right? So I'm wondering, will that, so do you have a vendor contract which would provide for shifting liability? It sounds like something will be negotiated, but yeah, and I think this could be imposed on small. That's a great question.
Hello. So you mentioned that the Colorado Attorney General is the ultimate overseer of this new law. What kind of training or regulatory oversight or expert consultants does the Attorney General get in order to make informed decisions about these laws?
So the Attorney General, that's a great question. I think Kathy mentioned she works not with, I don't know if it's is it the Colorado AG, Kathy? You work with the Colorado Department of Insurance, and I believe you said District of Columbia insurance regulator, but do you work with the Colorado AG? Okay. They're going to have to find someone in an ideal scenario, but that's a great question. The Colorado AG, Phil Weiser, is publishing a blog about steps he's taking. He's not saying, at least that what I've read before this, I've contracted with this very wise person to teach me more, for example, about algorithmic discrimination. I don't see that, so that's a great question. And that's almost like something I'd love to read about in the news, this department. All right, next question.
Thank you. So I'm an AI policy researcher, and I look currently at a lot of AI harms, and I realize that a lot of regulations are always covering high-risk AI systems. So my question is, we still see a lot of harm in low-risk AI systems, such as character AI, this recent case with a teenager, and then we also see advertising algorithms that are biased, and also this great book written by Safiya Noble about algorithmic oppression, and a lot of these are considered low-risk AI systems. So I'm just curious, from your perspective and maybe your experience, if there is any good ways or approaches that we can do to monitor or regulate low-risk AI systems.
One thing that has struck me, and it's something Kathy mentioned in her presentation about, and it's near and dear, I get hired by general counsel. What I'm finding is, and this is maybe representative, I'm not giving away anything confidential, I think companies want to do AI, I'm speaking generally, but I think they're playing it very close to the vest. And I think they're maybe not getting a diverse set of inputs, and I'm not speaking maybe in diversity in the way maybe people are thinking about it, but for example, someone like Kathy, some outside perspective, I think you just don't know what their process is. And so usually it's sort of like good decision making. You get contrary or different opinions and you have a process to work through them. And there are a lot of blind spots, like one person or one specialist doesn't know everything. If there could be a process like inside, internal, and out, external voices. The other thing I want to point out from companies, a lot of what I'm finding is AI is driven by executive leadership. They tell the general counsel, just make sure it's okay. And board of directors are really interested in this. They're pushing for this. Like they have an oversight function, like they should to provide oversight and almost, they're like championing this. I'm a member of something called National Association of Corporate Directors. They're all in. I attended they're all in. And I was they weren't all in. They were thinking of risks with privacy and security. So different voices to consider everything. Yes, there's sort of a great case to be made, but there could be risks, and can you see everything? And maybe, based on other things, whether privacy or data security, which is part of this, it's not all of this, be able to say, oh, this happened in this kind of scenario. So that, to me, is good decision making, but you don't have an explicit requirement in Colorado. It's just if you fall astray.
Do you foresee national corporations having issues navigating different state laws or conflicting state laws?
Absolutely. So this is happening with privacy and data security. So quite frankly, does every company comply with it? No, it's impossible. It's a challenge, quite frankly, to keep up with these laws. I pride myself on my knowledge of state laws. It's a lot. I mean, this is not a long law, but there will be rules. So you count the number of pages. California Privacy Rights Act, I mean, if you count the number, it's over 60. And do you go through the regulations? And one thing I'd like to point out, California is having regulations under the California Privacy Rights Act. It's not yet final. They're talking about automated decision making. That kind of gets into the area of AI. So I think when California comes out with something, and should they have a bill that's not SB 1040, or should SB 1047 be revived, who knows, people will stand up. Companies pay attention to California. That's why I'm thinking about population. They are paying attention to Texas. And again, population and a fairly active attorney general or who's rattled his saber. Did they pay attention to a smaller state like Colorado? I think they will now. Will they pay attention to Minnesota with a Privacy Act that goes into effect next summer and an attorney general? It's a smaller state. So it'll be interesting, but they pay attention when they see other companies penalized and they see their peers or who they benchmark against penalized. Do they comply with all? Some may, but I think it's the minority. Yes? Yeah.
Good morning. I'm wondering, so these laws, as you've described them, seem to be focused on the technology that is built on top of data, right? Like that AI takes data, chunks it, gives you an output, we make decisions with that output. Do any of the laws that you see coming up have guidance or language that helps to guide the industry on discerning whether the data that they're inputting is high quality for the uses that they're hoping to then use that tech for?
Not so much high quality. One amendment you're seeing in the consumer privacy laws in Colorado and in California is that they're now covering data which could be input, but they're not sort of characterizing it, if you will, as high quality, but they're covering it, which means there's sort of a blur between the privacy laws, like they're extending to this area, if you will. Does that make sense? Okay.
Yes, hi. When you talked about automated decision-making, does the law differentiate between fully automated or a human in the loop?
Some do. Perfect question. And did I cut you off? Yes, it depends. It depends on the law, but some do talk about sort of, if you will, a human intervention versus fully automated. Stay tuned for California.
Hi, Jennifer. Getting back to healthcare again, does Colorado or any of the other states looking at laws in this area, are they carving out healthcare and electronic health records, or is that something that is specifically being called out as something that they want more oversight of?
So that gets to the exceptions, and I did my two, yeah. Let's see, I'm just going through. The issue is, are these being carved out? If you wouldn't mind emailing me, I can email you the list of exceptions. I'm seeing financial services. I thought I saw insurance, which, while not healthcare, could deal, yeah. Oh, hold on. A peer-reviewed scientific or statistical research, I know that's not it. I'm looking for HIPAA. I'm not immediately seeing it, but I have a list of exemptions. If you email me, I can send you a list of exemptions. Anyone else? Oh. Is your question, if I live in California, I reap the benefits, or if I don't live in California?
So if I live in Minnesota,
yeah,
and I'm on an online form, can I just claim that I live in California to get the benefits? And like, is this a common concern?
Putting aside the obvious ethical issue with that, so state consumer privacy laws, if you've ever gone on like, here, request my data or amend my data or delete my data, it will ask you, are you a resident? So, you know, you're not ethically or otherwise complying. Some companies say, you know, we can't just, if we're going to do this for California, we're going to do it for everyone, but it depends on the company. So it depends if the company decides to extend it nationally, because they're probably, you know, are you going to treat residents of one, this comes up in data breach, like, oh, they have to, I'm making this up, they have to report in California, but they don't have to report in Minnesota. Are you going to treat the person in Minnesota who suffered a like different, like, oh, we don't have to report, but we do in California? We'll send a notice to the usually in data breach, you treat everyone the same. In the state consumer privacy laws, some companies don't want to let you exercise your rights. You could do that, but then you're not complying with the law and the terms, and maybe there's some issue for you.
Question about the timing of it. So we have been able to develop a lot of privacy legislation many years after the question of privacy really became an issue. But AI, we're hitting it very proactively at the forefront. Can you talk a little bit about some reasons we can and should be optimistic that these general terms are going to be refined down as AI develops in terms of, you know, use cases and actual harm done?
I don't know, but I agree with sort of what I think you're getting at. I think they'll be refined. Colorado's law is going to be amended. California's seriously considering, and I think they want to do it right. And I think it will be refined, but sort of also getting back to what Kathy was saying, you have to actually use it and find out. So it's sort of like the privacy laws, and I was around and doing the privacy work. Like sometimes you can't script what will happen. Like when I say, and I'll use data breach because I handle those, like I think this is going to be the call. No, it's like I couldn't script it. So I think it will be the same with this. We'll kind of find out from use and implementation, and that might help guide. But there's like different interests. There are companies who are the developers who have a significant interest. And another thing I mentioned, I was in the room with Kathy, I found it really interesting, like the California law, there was the Salesforce Dreamforce conference, and it was announced there, Governor Newsom is sort of tentative, and boom, then he said, oh, I'm not. After that, he didn't sign it. It's like, is it really kind of interesting, right? And so that sort of struck me, was there, big companies have their own opinions and their own interests, if you will. So there will be that, there will be people, it's an interesting space, but I guess watch it and watch for developments.
We have another online question. Would individual software developers be held responsible when doing job-required work?
They're talking about the individual, like the employee at the company. Right now, not as drafted. That's interesting. That's an interesting concept, but typically it's the company versus the employee. And by the way, the privacy and data security laws are, in other words, it's the company, it's not. But one thing, you are reading in data breach about CISOs, being personally sued. So the question is, could someone for an algorithmic harm or could they personally sue someone? I don't think there's anything to stop that. So that would be the analogy. It's not being sued under the law, but like you helped cause this. Thank you so much. Okay.